Oh, apparently it's my fault. I accidentally pressed the mute button. So I guess we also have all done that before, although usually not on handheld microphones. So welcome everyone. I would like to begin by asking that we take a moment to pause and reflect on some of the history that has brought us to this point and how we might individually and altogether contribute to moving forward on the path of reconciliation. This land on which the University of Toronto operates has for thousands of years been the gathering place for many Indigenous peoples from across Turtle Island. It has been stewarded as a site of learning, exchange, teaching, and sharing. This has been the traditional land of the Huron-Wendat, the Haudenosaunee, and the Seneca, and I also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Today, this meeting place is still the home to many Indigenous peoples from across Turtle Island, and we at the law school are grateful to have the opportunity to learn and work and to build community in a good way together on this land. I also want to acknowledge that our conversation this afternoon and evening about the global order occurs at a time of horror, grief, and anguish at the murder and abduction of civilians in Israel and at the civilian deaths in Gaza in the course of the response to those attacks. The shock and pain wrought by this conflict, I think, is felt all around the world, and it is certainly felt here in the law faculty and in Toronto and across the country. Now, a few words about this lecture. Everybody who is connected to the Faculty of Law will know that Dean Cecil A. Wright, generally known as Cecil Wright, was the founder of the modern law faculty at the University of Toronto, and in many ways one might say a father of modern legal education in Canada. He became the dean of the faculty of the law school in 1949. But he first had to resign his post as Dean of Osgoode Hall, which meant rejecting the Law Society's apprenticeship model in favor of U of T's vision of full-time academic legal education that brought legal education under the umbrella of a Bachelor of Laws degree and centered in a university. He was a person of enormous personal courage and drive, and his commitment to the academic approach to legal education was remarkable, and this is the legacy that we carry forward to this day with the particular approach to legal education here at the law school. Now, the lecture that bears his name is intended to be a lasting memorial to the contribution he made, and it is this faculty's most significant public lecture. In the past, this lecture has been delivered by a long, long list of illustrious scholars. I will mention only a few: Dean Harold Koh of the Yale Law School, Martha Minow of Harvard University, Hanok Dagan, then the Dean of Tel Aviv University Faculty of Law, and most recently Jedediah Purdy of Duke University. And we are today extremely fortunate to carry on this series of remarkable visitors with our very special guest we have here tonight. I will not say much more about our amazing guest because our tradition at the faculty is to have a faculty member introduce the Wright lecturer. And I really cannot imagine a better person to do so than our newest colleague, Professor Galit Sarfati. She holds a JD from Yale Law School, so you can see there are some connections that might also possibly come out in what she will say to us. She also holds an MA and a PhD in anthropology from the University of Chicago. She joined us this summer from the University of British Columbia, where she held a Canada Research Chair in Global Economic Governance. As a legal scholar and anthropologist, Professor Sarfati analyzes the ways in which law and legal institutions operate in practice, including the transnational regulation of corporate human rights compliance in global supply chains, the role of corporate actors in international lawmaking, the culture in international organizations, and also the use of quantitative regulatory tools in global economic governance. This year at the faculty, she's teaching public international law this term, and she will be teaching transnational business and human rights law in the winter term, although I always prefer to call it the spring term. We are very excited that she has joined the faculty, and I will now turn it over to Professor Sarfati to provide an introduction to our lecture.
Thank you so much. I'm extremely pleased to welcome Professor Oona Hathaway today to the University of Toronto to give this year's Cecil A. Wright Memorial Lecture. Oona Hathaway is Gerard C. and Bernice Latrobe Smith Professor of International Law at Yale Law School. She's a member of the Council of Foreign Relations and has been a member of the Advisory Committee on International Law for the Legal Advisor at the U.S. Department of State since 2005. She's published over 40 law review articles as well as a book with Scott Shapiro entitled The Internationalist: How a Radical Plan to Outlaw War Remade the World. But to me, Oona Hathaway is not only one of the most cited and influential international law scholars today, she is also my longtime mentor and professor from my days as a law student at Yale. I still remember arriving in New Haven in 2002 when I heard that there was a new international law professor who had just begun teaching at Yale that summer. I had already read Oona Hathaway's latest article at the time, Do Human Rights Treaties Make a Difference?, and immediately applied to be her research assistant. Despite the fact that I was just in my first term of law school, Oona graciously hired me as an RA, and I'm so grateful to have had the opportunity to learn from her, but also to have benefited from her extraordinary generosity, kindness, and support that inspired me to become a legal scholar myself. And now, more than 20 years later, I can say that her mentorship and wise counsel have made a huge impact on my life, and her scholarship continues to inspire me as well as countless others. So I'm very thrilled today to introduce Professor Hathaway, who will be speaking on the past, present, and future of the global legal order. So please join me in welcoming Professor Hathaway.
That was so sweet. Thank you. That was so sweet. Thanks. Do you want this back?
Thank you.
Thank you so much. That was such a generous introduction. Thank you, Gilly. And I think anyone who teaches knows that really the great joy of being at a law school is the opportunity to mentor and teach, and then in turn, in a sense, be mentored and taught back by our students. And I'm so glad to have the chance to spend this time with you. And thank you so much, Dean Bernice, for inviting me to be here. It's a great joy to get a chance to talk to all of you. I want to say up front, I debated as I was thinking about this, how to incorporate the terrible events that have been happening in Israel and Gaza into the talk, and decided that it's just too early for me to begin to make sense of what's happening right now. Honestly, I think it's just, events are still unfolding at an extraordinarily fast pace. I think we're all struggling to understand what's happening. And I think it's much too early to know how what's happening is going to impact the issues I plan on discussing today. I'm happy to try to answer questions that anyone may have during Q&A, and to do my best to puzzle with all of you together on how we can think about these really tragic events. I hope if any of you want to talk about that you feel free to ask the questions during Q&A. Okay, so my plan for today is, I know I've taken on this giant topic, so I recognize that this is a lot, and I'm certainly not going to be able to talk about everything anyone might want to talk about on the past, present, and future of the global order. But my plan is to try and begin with some kind of historical context, to think through what was the Old World Order, what in my work with Scott Shapiro I've called the Old World Order, the transformation from that to what we've had since the 1920s that we call the New World Order, and what are the key foundational principles of that order. Then I want to talk a bit about the war in Ukraine, which is, I think, the most significant challenge to the foundational principles of the modern world order since World War II, why I think that's the case and what we understand so far about what's been unfolding in Ukraine. I want to talk a little bit about the challenges that have been revealed by the war so far, and the impact of the war on global order thus far. So recognizing there's still a lot to happen, there's much we don't know, facts are still unfolding on the ground there, but I think we can begin to speculate about what the impact is likely to be and talk about what so far we've seen, though again recognizing that there's still much to unfold. So that's my plan for today. I've been told to speak for about 45 minutes to an hour, so that's my plan. And then I am looking forward to hearing from all of you with questions that you have. I hope that we'll have a conversation after that. Okay, so first, Old World Order. What do I mean by that? So just some background. This is a book that Galit mentioned, The Internationalists, How Radical Plan to Outlaw War Remade the World. This is sort of the framework that I'm going to be using for introducing this. This is work that I've done with my colleague Scott Shapiro. And there, one of the arguments, we start with Hugo Grotius, who's widely known as the father of international law. There's Grotius lectures, there's Grotius statues, there's Grotius fellowships. If you're an international lawyer, there's a kind of a Grotius everything. And when we were writing the book, we went back and actually read Grotius. I mean, he's sort of known as the father of international law, as well as the father of this theory of just war. And I was working with Scott Shapiro, who's a philosopher, not an international lawyer, and he said, well, I'm going to go read Hugo Grotius for myself. And he read it, and he came back and he said, do you know what this guy argued for? I said, well, he's father of just war theory. And, well, actually, his vision was a different one than I think we tend to realize. His view was that war is a permissible remedy for wrongdoing. His vision, though, of what wrongdoing was much more expansive than I think we would imagine today. So today, we think of war as being permissible for a very limited set of reasons, primarily for self-defense or if the Security Council authorizes it. But that was not Hugo Grotius's vision. His vision was war is just for the very reason it tends toward the attainment of rights, and in seizing prize or booty, we're attaining through war that which is rightfully ours. His vision was much more if there was a right that was violated, that war was the legitimate remedy for that wrong. Part of what we did for the book, and then we did in a subsequent article on war manifestos, and there's a database that we've made available on the Yale Law School library webpage that has our huge collection of war manifestos. As we went through and we looked at what states said, so not just, okay, so there's Hugo Grotius, he says these things, he's a scholar, maybe nobody actually listened to them. So we went to see what did states actually do, and we collected these war manifestos. So states used to, before they went to war, issue these war manifestos, and they're essentially these sometimes quite flowery declarations of their reasons for going to war, where they would sort of explain to their population and sometimes to other populations sort of what they were doing and what their claims were and why it was that they were going to war. So we read hundreds of these, and we cataloged the reasons that states were giving for why they were about to launch the war that they were about to launch. And these are the various reasons. Now, some of these reasons are familiar ones today. So self-defense, that's a familiar reason today, although they had a much more expansive idea of self-defense than we would see in Article 51 of the UN Charter. But a whole host of other reasons that were considered perfectly legal and legitimate reasons for going to war that today we would not consider to be legitimate reasons for going to war, like stopping those who would disrupt the balance of power, or enforcing treaty obligations, right? So nowadays, international lawyers spend a lot of time worrying about the fact that sometimes it's hard to enforce international law. But the answer that used to be the case for enforcing international law is if the other side violated a treaty, you could just go to war against them. Fortunately, I think, that is no longer an available option for most states and most of the time. So the Old World Order, we argue, put the privilege to use force at the center of the international order. And part of what we try to argue in the book is that several other principles followed from that central principle. So the prohibition, the privilege to use force was at its core, and all these other rights flowed naturally from it by logic. So, and I'm going to walk through each of these just very briefly to explain what I mean. So first, if war is legal, conquest is legal. So if war is legal, if you can go to war to right wrongs, so the other side has wronged you, you're allowed to go to war in response, well, of course you have to be able to get something. You have to get some kind of compensation, and typically that compensation was land. So land would be conquered. One example that we give in the book is the Mexican cession of significant amounts of territory from Mexico. And the justification offered by this lovely guy, President Polk, for the invasion was the failure to repay debts. So Mexico owed a lot of money to the United States. They actually entered into an agreement for regular payment of this debt over time. And then Mexico made the first couple of payments and then defaulted and failed to make any further payments, part because it was just very contentious time within Mexico. They'd had 32 governments in 31 years. There was very ineffective government. They just couldn't really pay. And so Polk did what he'd always wanted to do. He'd always wanted to seize this land, but they gave him a legal justification for doing so. Seized significant land in compensation, as compensation for the debts that were owed, and the cost of collection, that is, the cost of actually waging the war. Now, this is, from a modern perspective, extraordinarily reprehensible and horrific. At the time, this was considered sort of normal course of business. And if you look at any map, like some of you, perhaps some of you are like this, I find maps really fascinating. If you look at maps over time, you can see how much sovereign territory changes over time. If you look in the 1600s, 1700s, 1800s, up until the early 1900s, borders are constantly changing, and they're constantly changing in part because conquest was considered an available legal remedy. If war is legal, then gunboat diplomacy is considered to be legal. This is a woodcut drawing that was done it was a Japanese woodcut picture that was done when the United States showed up to insist that the Japanese enter into a treaty of friendship with the United States. This is Commodore Perry, who led the sort of first US mission. This was a steamboat which Japan had for hundreds of years been closed off from the rest of the world and was not engaging in regular trade relations with the rest of the world. And the United States showed up and said, you have to trade with us or else we're going to invade you. And they hadn't, most people in Japan hadn't seen steamships before because there hadn't been significant trade with the rest of the world except through very limited context. And so this seemed like this kind of very extraordinary thing. Now, one would say these days gunboat diplomacy is illegal, but at the time gunboat diplomacy was legal in part because if you can use force to get what you want, you can also threaten force to get what you want. And here they threatened force to force Japan into a treaty, and then that treaty itself is enforceable through a threat of war. If war is legal, then there can be no crime of aggression. So after World War I, there was an effort to try and hold those responsible for the war to account. But even the Dutch wouldn't turn over Kaiser Wilhelm II because they said, look, there's nothing illegal about waging a war of aggression. That was perfectly, the war of aggression was legal. There isn't any criminal act that's been committed, so there's nothing to hold him criminally responsible for. And last, if war is legal, then states can't favor either side. They have to respect what's called neutrality. And Woodrow Wilson, speaking in 1914, when he was running on the principle, he kept us out of war, that was the slogan, didn't manage to continue that for very long after he got reelected. But when the US was still out of war, he was arguing that we had to be impartial in thought as well as in action. So complete impartiality is necessary in order to maintain neutrality, which is required of any state that is not directly involved in the war in order to maintain that neutrality. In fact, a legal obligation not to show any kind of partiality in a conflict. And if you do, that is itself a cause of war for which the side that you're disfavoring can go to war against you. Okay, so now let me talk a bit about, hopefully that all sounds very foreign to you. Maybe less foreign today than it once was, but hopefully most of that sounds fairly foreign to you. So how do we get between there and here? So how do we get to kind of what I think is a very different legal order today? So in the book, we talk about this relatively unknown figure. His name's Salmon Levinson. He was just a bankruptcy lawyer in Chicago. He was not a particularly well-known person, but we came across his work and we realized he was one of the early thinkers. He's certainly not alone, but he's one of the early thinkers in really trying to think about this idea of not just regulating war, but outlawing war. And he wrote about this idea of not just having rules against war, that we should have laws against war, not just rules regulating war, laws of war. And he spoke and he wrote very movingly of it. He founded a non-governmental organization. He worked with politicians in Washington and around the world to raise an interest in this idea of actually outlawing war, of making war not just trying to regulate war, but actually making it illegal. And that effort ultimately did succeed. In a much maligned and a much criticized treaty, often known as the Kellogg-Briand Pact of 1928, it was the most ratified treaty of the world at the time. And in it, states agreed to no longer use war as a means of resolving their disputes with one another. Now, seen from a modern perspective, this seems fairly unremarkable. But at the time, this was a really significant decision to make, to decide to give up the right to use war to enforce legal rights. Now, as we all know, that was relatively short-lived. And obviously, World War II happens. There are many incursions before that. But this was a moment, an important moment, we argue, in raising this idea that war might be made illegal, or war for these purposes of enforcing legal rights and responsibilities could be rejected, and a legal order founded on a different set of principles put in its place. So whereas the old world order had this privilege to use force at its core, and then all these other rules kind of flowed from it, we argue that the new world order puts a prohibition on force at its core, sort of flips it on its head, and then all the rest of the rules have to also flip on their head, right? So they all become the opposite of what they were. And that's necessitated by the fact that where war was once legal and permissible, and a main way in which states enforce their legal rights, now it is prohibited, no longer legal, and therefore everything else has to change along with it. And moreover, I don't think, as we were writing the book, I think that the people responsible for that didn't fully understand how much the system relied on this idea of being able to use force to enforce the rules, and how much would have to change in order to make the system work. And part of the argument that we make in the book is that the prohibition on war is not just one legal rule. It is kind of the linchpin. It's the fundamental underlying principle. It's a thing that kind of makes the rest of it work. And when you flip that on its head, everything else has to change too. So let me say a little bit about how that began to unfold. So right away, states were not abiding by this principle. Japan, which had been at the signing ceremony in Paris, quickly turned around and invaded Manchuria in 1931. They had a set of arguments for why they could do that. They argued that the railway that was a Japanese-owned and run railway that ran through Manchuria, which had been granted to Japan through a series of treaties, had been attacked by Chinese brigands, they claimed. And that was a legal basis for being able to go to war. Turns out that it was some junior Japanese soldiers who almost certainly set the charge themselves on the railway in an effort probably to provoke a justification for taking over Manchuria. But whatever the case, Japan invades Manchuria. Even then, even if it had the argument that it was trying to enforce the rules against China, it no longer had the right to do that, because under the Kellogg-Briand Pact, they weren't permitted to use force to enforce their legal rights. and yet they do. So now the world was stuck because they had this set of rules that everyone had signed, the Kellogg-Briand Pact, saying no one can go to war with one another, and yet a state has gone to war. And there's this challenge. How do we enforce this legal rule? The central way in which these kinds of rules used to be enforced was with war, but we just signed a treaty that says we can't use war to enforce the legal rules, so how do we do this? The answer that they came up with was a fairly imperfect answer, but a clever one, which is this idea of non-recognition. Some of you may remember the Stimson Doctrine, which was articulated in a couple of identical notes that were sent by Stimson to both Japan and China, saying the US would not recognize the situation brought about by means contrary to the covenants and obligations of the Pact of Paris, another name for the Kellogg-Briand Pact. And League of Nations very quickly followed suit and also refused to recognize the conquest and to recognize the sort of puppet government that had been set up. So whereas under the Old World Order there was a right of conquest, now it's increasingly recognized that there was no legal right of conquest, that states can't unilaterally seize land from one another and have it recognized. In that same note, notice that they also say there's not going to be a recognition of any treaty or agreement that could be brought about by means contrary to the covenants and obligations of the Pact of Paris. So similarly, you can't engage in gunboat diplomacy, you can't use force to force a state into a treaty. Now that you no longer can use war to right wrongs, you can't use it to force states into a treaty. So where there was once gunboat diplomacy, now gunboat diplomacy was illegal. The next provision of the Old World Order to fall was the law of neutrality. So Robert Jackson in 1941, in assessing whether the US could engage in Lend-Lease, which was a program that would have been in pretty clear violation of the duty of neutrality under the Old World Order, because it was clearly favoring the Allies in the war vis-a-vis the Germany and its allies. Says, well, the Treaty for Renunciation War, yet another name for the Kellogg-Briand Pact, by the way. It goes by a lot of names. By altering fundamentally the place of war in international law, it's affected a parallel change in the law and status of neutrality. And he argued that that change justified the US providing support to a state that had unlawfully come under attack in violation of the Kellogg-Briand Pact. So where neutrality used to require impartiality, now it permits partiality, including economic sanctions, which, as you know, have become central feature of the methods of enforcement of international law today. And then last, this picture is probably familiar from Nuremberg. The first indictment in Nuremberg was based on the illegality of the invasions. So the invasions were specifically planned in advance in violation of the terms of the Kellogg-Briand Pact of 1928. This is the legal basis for the central legal basis for the setting up of the Nuremberg court. It's thought of primarily as charging the Holocaust crimes, and it certainly did, but the central legal basis for the creation of the court was the violation of the Kellogg-Briand Pact, the crime of aggression that led to the ability to create the court. And the reason this was different from after World War I, when, remember, Kaiser Wilhelm I couldn't be, Kaiser Wilhelm II couldn't be tried, what was different was that the states, including Germany, had signed the Kellogg-Briand Pact. And so they had violated that obligation, that legal obligation, and could be held criminally responsible for it. So where there had been a license to kill, there was no crime of aggression. Now aggression could be a crime. Now you may be thinking, what does all this got to do with today? And we tell a longer story in the piece. I don't want to take too much of our time today about how we kind of get from there to the UN Charter. But today the UN Charter, after World War II, Article 2.4 included within it this prohibition on use of force that was really had its origins in the Kellogg-Briand Pact. And in fact, we tell the story about the fact that the person who was a ghostwriter of the Kellogg-Briand Pact for Briand was actually the very same person who wrote the first draft of the UN Charter, which was written, initial drafts were written within the State Department even while the war was ongoing. And he intentionally his early drafts actually literally took the Kellogg-Briand Pact and put it right into the center of what would become the Charter. And that through various drafts, evolved into this prohibition on the use of force, which is now the core of our international legal order. So that central principle remains, and now we look to the UN Charter as the basis for this prohibition on war. But the key argument that I want to make is that that doesn't come out of thin air. Right? The prohibition on war in the UN Charter has this backstory, has this history that helps us understand how we got from a world where war was legal and legitimate and perfectly permissible, and states could use it to right wrongs, to a world where that's not true. And it wasn't just at the end of World War II that we kind of invented this idea. Okay, now I get the question all the time, what about the war in Ukraine? So I want to answer the question, what about the war in Ukraine? Because obviously the war is, I think, the most significant threat to the international legal order that I've just described. Right? If we are in a legal order where the central principle is the prohibition on force, and the central ideal is embodied within Article 2.4 of the United Nations Charter, and if, as I've argued, everything else kind of follows from that, all these other rules rely on it. It's not just one rule in the international legal order, it's the central, fundamental, underlying legal principle from which the rest follow, then the war in Ukraine is a really major threat. It's not just a threat to Ukraine, it's not just a threat to Europe, it's a threat to the international legal order writ large. So let me say a little bit about that. So you all, I'm sure, remember February 24, 2022, the war began, and things looked quite dire at first. It looked pretty much like what was going to happen was that Russia was going to, as Putin seems to have expected, just go in and wipe out its neighbor. And that was certainly an intention. There were significant incursions initially, lots of territory initially taken. And then something somewhat unexpected happened, which is Ukraine actually succeeded in slowing down the advance and then, in fact, even beginning to press back. But it didn't do it entirely on its own. And I want to say a bit about that. But first, I mean, it's worth noting when that first happened, you all may remember, if you cast your minds back to when the war started, at least in my world, many people were saying, well, this is the end of the international legal order. You know, this is just a small sampling of what we were hearing. Either it was the end of the international legal order or the international legal order never existed in the first place, right? So you know, there were lots of people who were saying, like, this is a signal either that we have not had an effective international legal order, or if we had one, this is the beginning of the end. And so far, at least, I think that has not proven true, although you know, there's still much to be seen. And what I want to argue is that while this is almost certainly the most significant threat to the international legal order since World War II, it's not just the violation that we should look at, but we should look at the response to the violation. We have to look at what happened after the war was launched, what the global response has been to the war. And that's true generally of international law. I will say, and that's generally of law as a whole. I think there's sometimes a tendency to say, oh, there was this violation, therefore what's the point? Rather than, oh, there was this violation, then what happened? You know, what was the response? How did states react to it? And what does that tell us about the vitality of that principle? So first, you saw pretty robust condemnation. The world, not every state, but over 140 states came together to demand an end to the Russian offensive in Ukraine. There was, shortly after the war, so March 2nd, there was a UN General Assembly resolution in which over 140 states voted to condemn Russia. Only 5 states, including Russia, voted against this resolution. It was a pretty overwhelming response from the global community to the war. And it specifically called out Russia for its violation of Article 2.4 of the Charter in language that's pretty strong for a UN General Assembly resolution. For those of you who follow, it's always very political and very careful and often, you know, cautious about making claims about legal violations. This language is stronger than what you will typically see in a General Assembly resolution. In fact, saying that this was done in violation of Article 2.4 and deploring it in the strongest terms. That's a fairly strong condemnation for a General Assembly resolution, and to get over 140 votes in favor of that is significant. And you saw fairly strong and robust condemnation in a majority of countries in every region, though, and I'm going to speak to this later, you can see that it's not uniform. You see the West and Europe, fairly consistent in its response, and I'm going to say more about the fact that that's less true in Africa and Asia, although, again, majority of each region did vote in favor of this resolution, and there's been, I think, 6 more since, which also have received significant support. The second response was what I've called my other work outcasting. So outcasting is basically involves denying disobedient states the benefits of social cooperation and membership. The work that I've done on outcasting is an effort to think through, if you can't use force to enforce international law, what can you use? Right, so how do you respond to violations of international law in a world in which you don't have available to you war, which used to be the old tool for enforcing the rules? And the answer is outcasting, or at least one of the answers is outcasting. Outcasting basically says there's a set of benefits that you would get if you were a member in good standing, and if you break the rules, we're going to withdraw those benefits from you. So just an example, under the World Trade Organization, if you violate the rules of the GATT, you put in place an illegal tariff, say, they don't send in the WTO police because there are no WTO police, and you can't invade a country because they've broken the trade rules, although historically you could have done that. But what you can do is you can put in place a countermeasure that is a violation, what would otherwise be a violation of the trade rules that's proportional to the harm that's being done to you. Right? So you're withdrawing the benefits that otherwise would be entitled, the other side would otherwise be entitled to. That's an outcasting. That's what I mean by outcasting. And what we've seen is massive sanctions. So sanctions are a form of outcasting. Trade sanctions are a form of outcasting. We have seen significant sanctions against Russia since the invasion, large numbers of them. This site, and I'm happy to share my slides. I have the links to all the slides. It collects all of the sanctions, all the different kinds of sanctions that have been put in place against Russia since the war, since even before the war. And you can see there's really significant, extensive sanctions that have been put in place. One of the largest set of sanctions that have been put in place against a country, again, since World War II. And Russia has been kicked out of a number of international organizations. It was excluded from the Council of Europe for its violations. So it's been suspended from the Council of Europe. It was suspended from the Human Rights Council, though it's making a bid to return, which hopefully will not be successful. So it was kicked out of the Human Rights Council. Now, third, in addition to these kind of condemnations and exclusion, there's also, that has made, the condemnation in particular has made possible affirmative assistance. So we've seen sort of unprecedented financial and military assistance to Ukraine from a number of countries. And again, this is a collection, the graph goes pretty deep, but these are the kind of chief contributors to support to Ukraine. And there's been substantial support to Ukraine, which has allowed it to actually succeed in responding to its much more well-resourced neighbor and stand up to significant assault by its much more populous and much better resourced neighbor. And this has been essential to its ability to survive. And I think it's important to recognize that the condemnation in the United Nations and the kind of repeated condemnation in the United Nations and the fairly uniform rejection of the legality of what Russia is doing has made possible, I think, this support. So without that condemnation, I think it would be much harder to justify and explain the support that's being given to Ukraine. And you hear, and we've all heard, Biden gives his speeches and leaders around the world give their speeches, that this is important to support Ukraine because Ukraine is fighting for, all of our rights, is fighting for our legal principles, is fighting for, is fighting for the principle that a state cannot simply invade its neighbor and take what it wants. And you're seeing that as part of the articulation of the justification for providing this assistance. And then fourth, we've seen efforts to prosecute those who are responsible for the invasion. So the International Criminal Court has been more active than it has ever been. It received referrals from 39 states and has begun investigating the situation in Ukraine. It has jurisdiction over Ukraine because Ukraine agreed to jurisdiction of the ICC, even though Ukraine is not a party to the International Criminal Court. It agreed back in 2014 to give jurisdiction to the court over events taking place in Ukraine. And so the International Criminal Court has jurisdiction over all crimes committed within Ukraine, in particular crimes against humanity, war crimes, and genocide. And it's been investigating those three. I can say a little bit more if anyone wants to talk about the crime of aggression. The crime of aggression is also in the statute of the International Criminal Court, but cannot be investigated by the ICC because of some particular ways in which the jurisdiction over the crime of aggression is structured, such that it can only be brought against a state party to the International Criminal Court. And since Russia is not a state party, the crime of aggression can't be prosecuted. But the other three crimes can be, and they are being investigated. And in fact, there's already been an arrest warrant issued for Putin over war crimes, and in particular, it was centered on the seizing and relocating of children from Ukraine. And there are undoubtedly many more of these to come, both of Putin and others. I've made an argument about, this is a piece I wrote, one of several pieces I wrote about a proposal to create a special tribunal to try the crime of aggression. So as I mentioned, the crime of aggression can't be prosecuted by the International Criminal Court. And so there's a move afoot to try and find a different way to prosecute the crime of aggression, because I see the prohibition on force as such a central principle to the international legal order. And the crime of aggression is the crime of basically violating Article 2.4, the prohibition on use of force. I think this is actually pretty important. And so I've been working on that. I'm happy to go into details in Q&A if anyone wants to talk about that. But I think that's an important initiative. It's very political and difficult. We'll see if we manage to make progress on it. But there's some serious concrete proposals to create a special court for that purpose. Okay, so that's a somewhat hopeful story, I hope, in terms of like what the pushback has been. The pushback to the war has been pretty significant and widespread. It hasn't succeeded in ending the war, obviously, but it has shown that there's fairly strong, consistent views of much of the world that what Russia is doing is wrong, is illegal, is in violation of international law, and that there have to be consequences for it. But we've also seen some challenges that have been revealed from these events, and I want to say just a little bit about that. So one question is, like, are sanctions actually working? So one of the main things that the world has done in response to Russia's invasion is to put in place economic sanctions. That's often the response in the modern legal order to illegal action, is to put in place economic sanctions. We can think of the situation in Iran. There were economic sanctions there. Sanctions have been used for human rights violations. Sanctions are used often in cases where there have been violations of international law. And this piece in The Economist detailed some of the efforts at sanctions. Half of Russia's currency reserves are frozen. At the time this was written, it was $580 billion. I think it's over $300 billion now that have been frozen in Russian central bank assets. Firms are barred from buying inputs and from engines to chips. The oligarchs are personally been subject to personal sanctions. They can't travel. Much of their money is frozen, and the like. And in the long run, a lot of the effort of these sanctions is to impair Russia's productive capacity. One of the challenges of sanctions with Russia is one of these kind of actors that sometimes we talk of as like too big to outcast, because it's such a central player, in particular in energy markets, that it's very difficult to exclude Russia from these markets without hurting the states that are doing the excluding as much as they're hurting Russia. So course, Europe is highly dependent on energy resources from Russia, and so closing that off entirely is quite difficult. And so there's been some efforts to put in price caps and other things to allow to not tank the European economies in the process. But a lot of the sanctions are also focused on kind of long-term kind of bending the curve. So things like not replacing chips, not allowing for selling of advanced replacement parts for airplanes and the like that are intended to have a kind of longer-term effect. So these have been very extensive. They've been fairly effective. I mean, the Russian economy has taken a pretty substantial hit. But they haven't done everything, and in part, that's because even as Europe and the West has cut back on buying from Russia, other countries have stepped into the breach. This is just one example, but India in particular has been buying a lot more Russian oil. China has bought some more Russian oil as well. They're buying it cheaper, so there's some financial hit to Russia, but still, even as we're cutting back on our imports, and in fact, the U.S. And Canada have very little trade with Russia, so it's really much more European imports have been cut back. Other countries are kind of making up the difference. And so that has really blunted the effect of sanctions, and often that's true of sanctions. They're blunted by the fact that there are states that are outside of the sanctions regime, and they're willing to do business with the very states that are being sanctioned. And there's worries that there's a kind of splintering in two that has been created by this. So we're kind of creating two economies. We've got the economy of the West and of the states that sort of share the view that what's happening in Russia and in Ukraine is clearly illegal, and who are joining the regime of kind of closing the Russian economy off. And then there's a set of states that are actually maintaining or increasing the trade that they're engaging in with Russia. And in a sense, we're seeing this kind of splintering of the global economy that's taking place as a result. And there's worries that that's beginning to unfold. And we haven't yet seen kind of where exactly that's going to lead and what impact that would have in the long term. We also see, and I mentioned this before, in the voting in the General Assembly, been fairly consistent votes. And consistently we're seeing, the West holding together pretty firmly, and the rest less so. I mean, so as I mentioned, Africa and Asia, the majority have voted in favor. Majority of countries in these regions have voted in favor of these General Assembly resolutions. But when you look to where are the abstentions, they're primarily in Africa and Asia. And I think this has been, or it should be at least, a wake-up call for the global community, that there are a number of countries that don't see this as being in their self-interest, even though in many cases these are countries that are extremely vulnerable if the prohibition on force is degraded, and if it's no longer the case that states can't count on the prohibition on force to prevent their neighbors from invading them. And I think this has led to some introspection, maybe more introspection is required, of why it is that these countries don't feel it's in their self-interest to support these resolutions. Now, they're not voting in favor of Russia. Very few states are joining Russia. Really, the only states are real pariah states that have nothing to lose. But large numbers of states are abstaining, and I think we need to spend more time thinking about why that's the case and how to make more states feel like they're part of, that they have something at stake here as well. And we've also seen, while the ICC has been much more active than it has ever been, and the level of support for the International Criminal Court is kind of at an unprecedented high, we're also seeing some infighting going on. That Karim Khan, the prosecutor for the ICC, has been critical of the idea of creating a special tribunal to try the crime of aggression. And there's some worries that there might be some infighting around this, and that could undermine support for international criminal law. And so that remains, I think, also a worry that we have to have about how this is going to unfold over time. And there's worries that there's limited amounts of money and support for these prosecutions. And so what's if the money is going to go to a special tribunal, is it not going to go to the ICC? And that's part of what's creating this infighting, this sort of sense that it's zero sum. And of course, the big question, will Ukraine survive this next stage of the war? And a lot of that will turn on the next US election. It's important to be honest about that. If US support disappears, then Ukraine is going to have a very hard time hanging on. We're also, in the midst of lots of political turmoil within the US and the whole question of whether US support for Ukraine is going to be able to be maintained. You all may have seen that the Ukraine assistance was taken out of the continuing resolution. There's going to be a fight over that in the next few weeks. And if the US support gets weakened, that is going to weaken Ukraine and make it harder for Ukraine going forward to succeed in this war, at least to hold on. And Putin knows it, so he's very aware of this fact. Okay, so what's the impact on the global legal order so far? With the recognition that we still don't know exactly where this is going. We're not that far into this. And so, unfortunately, I think this is going to continue to unfold over some time. But I think there's a few things that we can begin to say about what impact it's had thus far. One thing I think it's fair to say is that there really has been a revitalization of the General Assembly. There has been the General Assembly, the Security Council has been completely incapacitated because Russia has a veto and is able to block any action that the Security Council would take. But there has been a really interesting shift of energy towards the General Assembly in its stead. So I mentioned that there have been a number of General Assembly resolutions, and there's in fact also been this initiative that's sometimes referred to as a veto initiative that was put in place about a year ago, which provides that when a matter is vetoed in the Security Council, it's automatically referred to the General Assembly for debate. And that's an important step towards directly involving the General Assembly in any debate where a single member of the Security Council, a permanent member of the Security Council, vetoes action. It means that they have to explain themselves. It means that the General Assembly can debate the matter at some length and maybe even take some action. And so one of the questions we're seeing is how far is the General Assembly willing to go? What kinds of powers is it willing to take on? We've also seen the reactivation of the Uniting for Peace resolution, which was a resolution initially put in place in the 50s where, again, the General Assembly said that if the Security Council can't act, the General Assembly will take the matter up. And all of these resolutions have been taking place under the Uniting for Peace resolution. So we're seeing this much more significant role for the General Assembly. My own view is that this is generally a very positive development because the Security Council is notoriously underrepresentative of the world. The P5 members don't represent kind of modern political, any kind of reasonable representation of the world. It really was put in place during World War II. It was sort of political compromise between Americans and the Soviets, and it's not a particularly representative place. The General Assembly, where every state has one vote, is much more representative of the world as a whole. And so having more authority and power within the General Assembly, I think, is generally a very good development. And I think creates the possibility the United Nations might actually be more effective going forward if we can kind of continue this initiative of General Assembly playing a significant role in global matters. We've also seen, this is a piece I wrote a while ago, but I think it's still true. The U.S. finally sees the point of the International Criminal Court. We're seeing this kind of revival of the International Criminal Court. And a lot of states that were sort of skeptical of the ICC, the U.S. was a prominent one, suddenly seeing that there's some value in the International Criminal Court, that it can do something that nobody else can do. And so the U.S. has agreed to provide support to the ICC, which is pretty unprecedented for the U.S. because we actually used to have a law, still have a law that impedes cooperation with the International Criminal Court. And the U.S. is engaging in information sharing and support and assistance in ways that has been unprecedented. There's unprecedented support for this investigation in Ukraine. And I think we're seeing the possibility the ICC could really revive its role in the global community and its role as a kind of place of last resort for international criminal law enforcement. And it's beginning to capitalize on that in, I think, mostly quite productive ways. And so there's some hopeful signs that this is going to be positive for the ICC. And we've also seen renewed attention to the prohibition on war. I think there's a way in which many had kind of come to take for granted the idea that it's legal, that it's not legal for states to invade their neighbors, and that the prohibition on war is something that can be taken for granted. Now, obviously, we can point to examples where it's been violated in the past. It's not been perfectly observed by any means, but I think for many countries and for many people, this was a real wake-up call, a real moment to realize that we've been lucky to live in a world where, on the whole, we've been able to trust that these kinds of wars are not going to take place. And that the fact that this war has taken place makes us step back and think, is this the kind of world in which we want to live, where states have to constantly be in fear that their neighbors might invade them or that other states might choose to invade them. And the global community's response, I think, is an answer to that, which is many think that this is a central legal principle worth defending. And that kind of global response, I think, is representative of that. But the long-term effects are still really uncertain, right? We don't know exactly how this is going to unfold. There are a lot of questions that we still don't have answers to. Will the global economy hold together, or will it fracture? And what impact will that have if it does? Are Ukraine's allies going to stay the course? In particular, is the US going to continue to maintain its support? What will China do? Big question. It's sort of stayed somewhat on the sidelines through much of this. It's abstained in all of these votes in the General Assembly, interestingly. It's continued to trade with Russia to some degree, though it hasn't sold the level of arms that clearly Russia would like, and so it's turning to places like North Korea to try and get some of those arms that it's not getting from China. But will China maintain that stance? What role is China going to play as this unfolds? Really unclear. Does Putin have the internal support? And we saw, obviously, the sort of attempted coup within Russia that was a surprise for many. And Putin seems to have kind of reinstated his kind of stability. But I think that's got to have shook him and maybe created some concern that a future coup might be more successful. So that's still to be seen. And it's led to much more repressive actions within Russia, which in the long term could have the impact of leading to more resistance or not. I mean, those are the questions that we're going to have to see as it unfolds. Are these justice mechanisms going to live up to their promise? They're really slow. They're really expensive. And there's a lot of hope put in them. And the worry is that hope will be disappointed. And so while I'm very optimistic about the fact that the ICC has been moving forward, been investigating, been collecting evidence, been collecting all of this to be able to move forward with these cases, there's inevitably the possibility of real disappointment as well. And I think we have to be aware of that. And obviously, we don't know what the atrocities that have recently been committed, what impact that's going to have on all of this. There's worries that it could draw resources away and attention away from what's happening in Ukraine, that it might cause a broader conflict within the region. So these are all unknowns. The answers to these questions, unfortunately, are going to determine the future of the international legal order. But I hope the lesson, too, is sometimes, when you take on these big questions, it's easy to kind of get lost in, how big these are and how hard these issues are and how little control we have over the answers to any of these individual questions. But at the same time, it brings me back to the fact that, when the transformation of the international legal order took place, what Scott and I traced in our book in The Internationalist, in many cases, it was individual people with deep convictions about their ideas who had this vision of a world in which war would be illegal that, were totally irrational. The efforts that they were making, their campaign to outlaw war was utterly irrational. And yet, in many ways, it succeeded. And so there is a power of ideas, there's a power of ideals, and there's a role for the kinds of things that happen in the university for trying to help make the answers to these questions turn out in the right way and to maintain and secure and improve the global order as we know it. So I'll pause there and look forward to your questions.
All right, thank you so much, Oona, and not only for the tour de force, but also ending with these quite powerful observations that you made at the very tail end about the role of ideas and the role of people and also the role of universities. That's why we're here to have this conversation. So we now have a good amount of time for you to have a chance to engage. Oona Hathaway, and I will field questions and also serve as the person who will get the microphone to you. So
that's great.
All right, we've got already a little bit of a queue here, and maybe you can each briefly introduce yourselves as well so Oona knows who's asking.
Thank you very much. My name is Malcolm Thorburn. I'm a faculty member here. And my instinct coming into the talk was to agree 100% that Ukraine was special and was a challenge to the New World Order, unlike any other war we'd seen in a long time. And I was trying to figure out what it was about that made it the case. Because not only Russia's invasion of Crimea earlier, but there have been plenty of other illegal invasions where my instinct was exactly shared with yours, that they weren't the same kind of challenge. And I wondered what it was about this one. Is it the fact that there's a sustained effort on the part of the international community to resist and that it's been successful? Is it the fact that it has been, we could say a little bit more about what it is precisely about this war, not just the fact that it's an invasion, but it's one that has been an ongoing challenge, back and forth, back and forth. What about it makes it that kind of challenge?
Yeah, great. That's such a great question, and I'm interested in all of your answers to that too. But let me begin to give mine. I think part of it is on the eve of the invasion, when Putin was sort of explaining why he was launching the war. It was a series of justifications that sounded just like an old world order manifesto. Like if you had printed that out and like backdated 100 years, 120 years, it would have fit right in. The kinds of arguments that he was making were the kinds of arguments that used to be good arguments. That NATO is, creating these threats that we have to protect ourselves against, and the fact that Ukraine might join with NATO, poses a threat to us. That there's threat to Russian nationals within Ukraine, and we have to invade to respond to those threats. That Ukraine doesn't really exist anyway. It's not really its own independent country. That's a sort of made up. It's made up claim. There's been a lot of rhetoric around that. But again and again, all the arguments that were being made were just blatant arguments that fly in the face of anything that's actually a real legal argument that's permissible. Now, Crimea was absolutely a huge threat as well. I think what the difference between the invasion and seizure of Crimea and this invasion of the mainland is that when that happened, it was all done in stealth, right? It was sort of these little green men sort of show up. And nobody really knows, we kind of suspect that they're Russians, but we're not 100% sure who they are. Maybe they're separatists, maybe they're something else. Who are these people? And then there's this referendum, and okay, well now we're thinking that's probably being orchestrated by the Russians, but maybe not. And they're sort of claiming this is sort of the people themselves speaking. And then it becomes clear, 2 months later, Putin's like, yeah, those little green men were our guys, but that was after it had already been annexed by Russia. And never was there this sort of idea or this claim that we have the legal right to annex it for all these various reasons. I think part of it is just the blatant claims, the blatant assertion of legal rights that are fly in the face of what are legal rights that are actually acceptable. And there were various reasons that people could explain away or try to explain away Crimea. Well, it has this like different kind of history, and it's a lot of Russian nationals, and sort of the Black Sea Fleet has long been, and there was this sort of backdoor deal, and maybe it didn't really belong. I mean, none of us who are international lawyers thought those were good arguments. It's always been like a clear illegal conquest, and the largest illegal conquest before Ukraine, before the invasion of mainland Ukraine, the largest illegal conquest in Europe since World War II. So it's big, it's really important. We write about it in the book as like a really substantial violation of the international legal order. But I think for me, at least, part of what's different is the kind of blatantness and the effort to justify in terms that are so old world, and without a recognition or willingness to accept the idea that these are unacceptable legal reasons. And then the fact that the world says, no, wait a minute, those are not, like, that's not a world order that we want to live under, and we don't accept those as valid legal reasons. And the kind of very significant, almost uniform kind of pushback that you see against that effort to make that set of claims, that to me makes this a really poignant moment for what the future of the international order is going to look like.
I'm David Eisenhouse. Thank you very much. It was a great lecture.
Thanks.
And the way that you answered Malcolm actually helps me to formulate my question better, I hope. I come from South Africa, and I follow the events in South Africa pretty closely on a daily basis. And what I'm about to say now, I don't want to be taken as any endorsement of things that the African National Congress government has said over the last few years, because I actually find the statement they made about the recent events in Israel-Palestine completely appalling, and I found their support for the Russian invasion of Ukraine completely appalling. But I still have some understanding of why there is this kind of phenomenon in South Africa, and maybe in large parts of the rest of Africa. So when the African National Congress looks at what's happening in Ukraine and in Israel, they would say, and again, this is not my view, that your and Scott's book was completely naive. Why? Because there'd been many wars since the Second World War. Many of those wars were sponsored directly by the United States of America. When the United States of America went into Iraq, of course, what they didn't do so in a blatant way. There was this huge effort to justify things in terms of the modern order. But still, it's the case that over time, the US, perhaps more than any other state, has weakened this order that you and Scott described in your book. And so it's no surprise that now Russia could come along, invade Ukraine, and to some extent, you know so much more about it than I do, I actually thought that there was more of an attempt to dress up the invasion in the new language, the post-Second World War language, than you suggested a moment ago. So even this idea of NATO encirclement, this is self-defense, right? And Lavrov, who's, I think, a horrible man, but actually a very intelligent man, in a lot of the things that he said towards the beginning of the invasion, he did use this language of the new order in order to try to justify what was happening in Ukraine, not talking about war, but still using the language of self-defense, and then pointing to what the US has done over the years that have weakened the order which now the US claims to be protecting. So I'm just wondering how you respond to that kind of criticism.
Yeah, I mean, you know, I agree with it, a lot of it. So I actually just published a piece in the Harvard National Security Journal that argues that basically makes the argument that the weakening of US war powers rules, which allows the president to use military force without significant limitation from Congress, has contributed to the US's gradual erosion and continual kind of pressing of the edge of the envelope when it comes to self-defense, and that in turn has weakened the international legal order by sort of expanding the scope of what are seen as justifiable arguments under self-defense. So let me just say a little bit more about that. And we say this briefly in the book too, not as robustly as I do in this separate piece. But so the U.S. has used has lawyers who are very good at making these arguments in the language of self-defense. Now, under Article 51, which is the UN Charter, Article 2.4 prohibits use of force, but the main exception in the Charter is acts of self-defense. And self-defense in cases where there has been, it specifically says where there's been an armed attack. And so that's meant as a very limiting principle, and we make an argument in the book that was meant to be a very significant limiting principle on self-defense. And in fact, during the Calabria Pact negotiations, they were debating whether to include a specific exception for defensive wars. And they ended up deciding not to because they were worried that if they included an exception for defensive wars, that exception would sort of swallow the rule. And I think they were incredibly prescient in that worry, because when they created this self-defense exception in the Charter, and they tried to narrow it by using this language of like you've come under armed attack. And it's supposed to be only until the Security Council then is able to meet and act. So it was supposed to be kind of an interim action. That has been gradually expanded through clever lawyering, and this is actually a cautionary note to the law students in the room, like lawyering can lead in the wrong places. I wrote a separate article called National Security Lawyering, which is kind of how, when I worked at the US Department of Defense, how I saw that process happening. And I think it's corrosive. And the US began expanding self-defense, and its latest version, so I walked through in the article, I won't bore you all here with the details, but latest version, the US has articulated in the last few years in Syria is an argument of collective self-defense on behalf of non-state actors in the north of Syria in support of, so claiming that we have a right of self-defense to actually act to defend these non-state actors who are assisting us in the counter-ISIS fight, and that allows us to defend them against their own government. So against shelling, and attacks from Syria in Syria. And I'm extremely critical of that.
I found this on the web.
Uh-oh, okay. That might be my phone. I think that then you see echoed in Putin's speech. You see that very same language echoed in Putin's speech. He talks about acting in collective self-defense of Russian nationals and the separatist governments that they had recognized in eastern Ukraine. And so I think the criticism is a very fair one. The U.S. has, and I make the criticism in this piece, I think the U.S. has not appreciated the fact that when the U.S. makes these arguments, it legitimizes them for everyone else. And when the U.S. is making these claims, which are every step is sort of pushing the envelope a little bit further, and you get to the point where the envelope is pushed so far that the underlying principle that you're trying to protect collapses. And then here we are. So I think that's right. And I think that that's something that when you're in the middle of it, and again, I worked for a year in the U.S. Department of Defense. I was a special counsel to General Counsel, and so I worked on some of these matters, and I came away from that realizing the difficulty is that the people who are making these decisions are just thinking about the thing right in front of them. You're thinking about now, this particular thing at this moment. You have no kind of historical perspective or context to see where what you're doing right now and the justification you're making for this thing you think is a good idea at this moment, what is the long-term implication going to be of that? And in fact, I was working on the book with Scott while I was at the Department of Defense. So I was going down during the week and working at the Department of Defense, and then coming back and working on this book, and seeing how what we were doing was not taking into account this longer historical perspective and the harm that was being done to that longer term picture. And again, I think that's a role academia can play. I think in Washington especially, and I imagine this is true in other capitals, things are very tunnel vision, and they're very focused on like, this problem I have in front of me at this minute. And you come up with a justification that sounds kind of good, and you can kind of get away with it. But our job, I think, is to kind of think in bigger historical terms and see where is that going to lead you if you make those steps, and try to make the argument that those, while they're tempting and while you can see why lawyers might want to make those arguments in the moment, the long-term historical impact of that is going to be extraordinarily destructive. So yeah, I mean, the short answer is I agree.
All right. Hi, Jillian Hadfield. So I managed to get through 30 plus years of a career as a law professor with my head in the sand about international relations, international law. So I want to thank you very much for the past and the present part of this, because a lot of that is new to me, and you did a beautiful job. So I came in to get educated. I got educated. Thank you. I want to focus on the future part, because what I have been spending the last 6 or 7 years thinking about is artificial intelligence. And that has actually brought me to the point where I was like, oh God, I need to learn about this, because all of a sudden that's become the framework for thinking about what's going to happen in terms of governance. So before ChatGPT, I would have said the US isn't going to do anything. Post ChatGPT, it's very clear that the US is going to act, and it's going to act within the framework of national security, relationship with China, and then just thinking of Taiwan, the chips are there. There was something, I haven't even had a chance to catch up on it, of sort of restricting access to not just chips, but also AI technologies and models in China.
Yeah.
And so now I can't say, oh, I don't think about that stuff. People like Professor Hathaway think about that stuff. Anyway, so I'm just wondering on the future part. Have you been thinking about the AI component? If so, I'd love to know what you're thinking.
Yeah, I mean, I think there's a lot of things to be said about the AI component. I mean, I think the thing I worry about is the way in which it will expand the capacities for waging war, and in lots of ways. So I also do cyber conflict. So we're going to see that continue to expand. And AI allows you to iterate, constantly iterate in ways that I think it's harder for humans to do, and that's I think fairly dangerous. It also has real implications for like the other side of what I do, national security issues around like security of information and the capacity to sort of maintain any sense of privacy. So I've written separately about the impact that it's going to have on our national security, because we have all this information about all of us in the wild, and in the hands of a lot of private data brokers. And you take all that information and you connect it with AI, and all of a sudden our adversaries are able to track us individually, to kind of know immense amounts of information about us. And I think it's a massive national security risk. And I wrote about this in Foreign Affairs about a year ago, kind of the AI risks for national security. I mean, on the targeting side, unfortunately, I think it will increasingly be used in targeting. Some of that will be intended to try and minimize civilian casualties. You could use AI to have the machine basically watching to determine like what's the likelihood that there are civilians in a building. And in a way, one can't really argue that that's a bad thing. Like one would say, okay, like you can't have human eyes on that 24/7, or it's very expensive to do that. But if you could train a machine to be able to identify, like this is, are there civilians going in and out? How is this actually used? What kinds of patterns can we determine? Is this likely to be a human child rather than, an inanimate object? Which I'm doing a separate project on what we're calling mistakes in war, where it's uncanny how often on film, on video, targeters mistake children for inanimate objects, and then turns out later, obviously in a casualty report afterwards, you realize actually those were children. So AI could do a better job of that probably than human beings, and in a sense one might say that that's a good thing. But on the other hand, it will expand the capacity to use these tools, and it will also make us think that there's lower cost to using these tools, and I think that's a dangerous road to go down. So yeah, I'm concerned about all the ways in which this is going to have an impact on kind of all the national security questions that I'm interested in. So yeah, I mean, I think it's hard even to begin to conceptualize what those problems are going to look like, to be honest.
So before I go to the next question, I also want to make a special point of encouraging the many students who are here, who are evidently very engaged. Please do not feel any hesitation whatsoever if you have a question that you would like to ask, to add them into the queue. Okay, there's 2 already.
Yeah,
so we
great.
have 1, 2, 3, 4, and we'll keep going.
Awesome.
Oh, 5. Okay, excellent.
Hi, my name is David Beatty. Thank you, Oona, for your talk. I enjoyed it immensely, and I enjoyed reading the book. My question really is to try to link the past, present, and future rather than just focused on the future, and to press you a little on how much different the past is from the present and the future. And I say that for 2 reasons. One, to pick up David's point that today we say in the UN Charter that the only grounds for the use of force is self-defense, and yet the Americans have been the leaders in expanding that concept, and not just recently, but in the 80s in Nicaragua and in Iran. And in both cases, not only did the Americans make this argument of self-defense, but they ignored the legal institutions that ruled against them. And so when I look at the past and I think of Grotius, I see a world in which there were no alternatives to righting wrongs other than the use of force. And today, I'm wondering whether your thought on the efficacy and the strength of our international institutions when the Americans say we're going to ignore the International Court of Justice in Nicaragua and in Iran, and when the Russians today are saying the International Court, I'd be interested to hear your thoughts on the International Court of Justice handed down a judgment. It was a tangential ruling, but they, in the course of the judgment on the Ukraine, they told the Russians that this was an act of aggression which they should stop, and the Russians, as the Americans, simply ignore it. So when I look at this world, I see a world that's very similar to the one that Grotius faced, that there are no alternatives to war, that the international institutions have failed us. Then in that world, might makes right.
So I don't disagree with the particular points, but I think I disagree with the place where you land. If you look at history, things were radically worse. I mean, as bad as we can point to lots of problems today, and we can point to lots of like failures in the United States. I'm as critical of the United States as anyone. But we are not seeing, if you just look at the data, and in the book we looked at the data on conquest of territory. If you just look at conquest of territory was extremely common in the Old World Order. Land constantly was changing hands in violent and brutal and bloody conflicts. We now see Ukraine as a kind of exceptional case. Hopefully it will remain an exceptional case, where we've had Crimea as the first case of significant conquest of territory in Europe since World War II. We don't see land changing hands through violent means very often, and when we do, though, we see them as exceptional and terrible instances. And again, as I said, you can just look at a series of maps to see how different the world looked from year to year, from decade to decade, historically, and that is not true today. And so in that sense, like, something is going right. You know, like, for all the despair and for all the problems that we have, and we have many, many problems, and I don't want to suggest that there isn't, you know, massive conflict around the world, and, you know, even as we've seen interstate wars decline substantially, we've seen intrastate wars, that is wars within states, go up, you know, so that is a serious problem and a challenge that we're facing. Nonetheless, this is a much more peaceful time than ever, despite the horrors that we have. And it's easy sometimes to lose track of that, or to lose a sense of how violent and destructive the world once was, and how many people lost their lives in these violent wars between states. And so while it's certainly the case the US, you know, has not been a great actor before the ICJ, nonetheless, the US most of the time does try really hard to abide by international law. And again, we can point out lots of examples where it doesn't, you know, so again, I write about that a lot, and, you know, determined to hold my friends in the US government to their best principles. And yet I think we don't want to overstate the case and suggest that there's this kind of lawlessness. You know, there are lots of very good, hardworking lawyers within government who are trying very hard to ensure the US is abiding by the law, and most of the time it really does. And not only does the US abide by the law, but it takes significant steps to try and ensure that others do as well. And I think it has mostly been a force for good when it comes to enforcement of international law, though the instances where it doesn't, and its failures, are all the more terrible and noticeable and harmful for the fact that it has otherwise this pretty good reputation, I think mostly deserved, for abiding by international law. In part because, honestly, it abides by the law because a lot of these rules are rules the US is own making, so it has a real interest in abiding by those rules, right? So it's not that it's doing it out of the goodness of its heart. But anyway, I think that would be my short answer. I think it's easy sometimes to get lost in the failures, but I think we also want to keep sight of, like, what is working. Like, there is a lot that is working. And the same thing is true of domestic law, and this is something I sometimes try to, when I'm teaching international law, it's often students have an inclination to sort of see the failures, and there's plenty of failures, and we study the failures, and, you know, we center on the failures often. But it's also important to remember there's lots of successes, and the world is a much different and more peaceful place as a result of international law mostly working most of the time, as the saying goes. And the same thing is true in domestic law. You know, I mean, do the rules against theft work perfectly? No. Are we all somewhat safer because the rules against theft mostly work? Yeah, sure, you know. I'm not afraid that somebody's going to be running through, grab my bag and run out right now, right? So you know, this is true of law generally. Law is rarely perfect and rarely perfectly enforced and rarely perfectly followed, and international law is no different in that respect. So I think the challenge for us as international lawyers is to see where are the patterns of failure and how do we try to strengthen and respond to those, but also not despair that, you know, nothing is working and that international law is, you know, not worth it. So anyway, I'll leave it there.
So if you wouldn't mind, when you've asked your question, pass it to the back row, and I think we're going to take sort of 2 questions in turn, and please.
Yeah. Great.
I'm Andres Kazakamp. I'm professor of modern European history at the Monk School of Global Affairs next door.
Oh, great.
Short question. You mentioned in your presentation your work on the creation of a special tribunal for the crime of aggression.
Yeah.
Seems to me this is very crucial. I'd simply like you to expand on that and what are the prospects for it actually happening?
Yeah, so there's a lot I could say about this. So, yes, sure, yes. No, that's great.
Right, I'm a doctoral student in the School of Law. I just want to contest you about the part of the participation of the countries in the legal order of the New World. Because since we look at the General Assembly voting, views from the global South would seem that the silence speak louder than the actions, and the abstention is actually a kind of half participation of this country in this institution. So it's still it seems that the new world still looks very much like the old world, with the drag of the great power and multipolarity. I'm just wondering what your views of whether that these new institutions are actually working. Is there any kind of are we morphing toward a better custom of engagement, or this simply seems very forced for this country?
Great. Well, let me briefly take the second question first and then return to the first one. So on the abstentions, I mean, I think that it is, as I said before, I think we need to try to understand why the abstentions are happening. What's interesting is there are abstentions, not votes, with Russia. So that's, I mean, to me, that's a hopeful note. There were only 4 countries that voted with Russia on most of these resolutions, and these are sort of the kind of outcasts of the world that are voting with Russia. Most of the rest of the states are abstaining. I think in many cases they just don't want to take sides in this great power conflict. And in some cases because they want to maintain ongoing trading relationships with both sides. And in order to maintain this ongoing trading relationships, they don't really want to anger either side. And so and in many cases, I had a student who did this really interesting paper that looked at all of the African countries that had abstained and traced where do they get their arms from, how much trade do they have with Russia, and in many cases they get a lot of their food from Russia, they get a lot of their arms from Russia, so it's not a huge surprise that they would be abstaining and not voting against Russia. It's actually sort of a surprise they abstain and they don't vote with Russia. So, but that said, I think it does suggest there's work to be done in terms of trying to make sure that this is not just a project of the West, that the global South is heard and is part of the conversation. I think there's been realization of that. I mean, at least with the people I work with at the UN, I think there's recognition that this is important. On the special tribunal, so the challenge is that the ICC, which has jurisdiction, can't proceed with the prosecution of the crime of aggression, even though it's in the statute, for the reasons I mentioned before. And no court has jurisdiction as a result. No international court has jurisdiction. Ukraine's own courts, they actually do have a crime of aggression in their own domestic statute, but sovereign immunity principles, head of state immunity, prevent Ukraine from prosecuting the top leadership of Russia. So under international law, states can't bring the sort of top leaders, the kind of so-called troika, the head of government, head of state, and the foreign minister to account in their domestic courts. And it's also the case that Ukraine has lots of problems with its own court system. So the question is whether it's really the right place to have these cases. Even Ukraine says, this is not the right place for these cases to go forward. And so there's been this effort to try and find an alternative forum and to create a special court for this purpose. And it has been so interesting to be a part of this conversation. I think the principled case is incredibly clear. The principled case is this is the most blatant and unapologetic violation of Article 2.4 that we've seen. And it's been condemned by the vast majority of nations in the General Assembly in explicit terms. And that is the definition of the crime of aggression. They basically called out Russia already for the crime of aggression. So there's a clear reason to think that this is a case where whatever one might say about all these other wars that have happened, this is the first time we've seen this kind of coalescence of countries in sharing the view that this is a clear violation of Article 2.4 and they're willing to condemn it as such. Politically, it's just really hard. I'm discovering. I'm learning a lot about internal politics. So the proposal that I have supported is a proposal to do this through the General Assembly. So to use the Uniting for Peace resolution and use the techniques that's been used to do these series of resolutions, to use that for the General Assembly to recommend the creation of the special tribunal to try the crime of aggression that would be negotiated by a treaty between the Secretary General of the UN and Ukraine, and that they would set up a court through that process. would look a lot like what was done for the Special Court for Sierra Leone, or the Cambodia Tribunal, although the Cambodia Tribunal was set up as a domestic tribunal. I think most people think this is the best way to do it. I don't think I've heard good arguments that on a principled basis it's not the right way to do it. I think there are concerns politically about whether it's going to be able to get the support in order to move forward. And in fact, the G7 is reluctant to support it, and I think worried about it backfiring against them, to be honest. And so, there's a process now underway to try to figure out, is there any alternatives? Is there any way to build support for it? Is there any other principled alternative? I'm not sure there is a good principled alternative, to be completely honest. And so that's, it's not enough just to have the best argument. You have to also get people on board with that, and I'm discovering that. And a lot of it is trying to build support around the world for this idea. And getting states on board with the idea that the crime of aggression is this fundamental, that it is so important to the global community establishing in response to what Russia has done, its shared conviction that this is utterly unacceptable, and that part of that ought to be using all of the legal tools at our disposal, which includes prosecuting the crime of aggression, which, as I said, showed before, like that was one of the things that's made possible by the New World Order and by the idea that war is illegal, and that crime can actually be, that war can actually be a crime. And this one, if anyone is, clearly is. So yeah, it continues to be a learning experience, I shall say. And I'm happy to talk about it more, but yeah, maybe I'll leave it there. But there's a lot of complex legal issues connected to it. Great.
And maybe I'll let you answer this, Oona, as I race over to the other side.
Okay, got it.
Hi. Thank you so much for this presentation. It's funny, I'm still thinking about the question, but I guess I should preface it with the first question. Did you watch Oppenheimer recently?
I have not. I have to admit, I haven't seen it yet. I know
Okay.
it's terrible. I have the book sitting on my bedside table at home, and I want to read it before I see the movie. So I'm sorry. I have to admit I haven't.
Well, that's all right. I just wanted to ask. We didn't really talk much today about nuclear warfare, and
Yeah.
it's a topic that's on, I'm sure, a lot of people's minds. And I don't know really. I mean, I guess you can look at history since 1944 and say that there were times when the world was close to nuclear warfare. Like, I guess you could point like the missile crisis in Cuba in the 60s, and we're seeing like, and as nuclear war has just gotten so much more powerful, the research into it has just exploded, but it's taken off.
Yeah.
It's there's implications, right? And so I'm just curious, what are your thoughts on that, and connecting your thoughts on that with the themes of today's presentation and the global legal order specifically?
Yeah, no, that's great. And I'll try to answer this quickly while you go to the next student. I think there's a lot of lessons to be learned here. I think one thing that is interesting is that while there was a lot of kind of saber rattling at one point by Putin and Lavrov, sort of seemingly suggesting that they were not taking nuclear weapons off the table, and thank goodness they haven't used them, and they don't seem likely to do so in the near future. I think that alone is actually like there was a lot of fear early on that we were headed in the direction of potential nuclear war, and we were closer to nuclear war than we had been since the Cuban Missile Crisis. I think that fear has receded a bit, and that is both obviously incredibly positive. There's also something interesting in that, though, because there was a belief that the fear of use of nuclear weapons is part of what tamped down some of the likelihood of conventional warfare between nuclear armed states, and the fact that maybe the threat of nuclear arms is beginning to look a little bit like a paper tiger, or that states are, thank God, again, not willing to use nuclear weapons. If that becomes accepted, a fear that maybe, ironically, that makes the likelihood of conventional warfare more likely, because we're less likely to see a nuclear result. Again, no one's going to say that that's a bad thing. Everyone's going to say that's a great thing. But it is, I think, we're watching this lesson unfold in real time. And it's one of the reasons, for instance, the U.S. hasn't come to the direct assistance of Ukraine, right? So all of this has been indirect. We've been sending them arms. We've been training them. We've been ratcheting up the level of support we've been willing to provide over time to kind of see where is Putin's red line. So far, we haven't hit it. But the reason we haven't directly come to their aid, because legally we're permitted to this is a solid Article 51 argument, right? Collective self-defense of a state that has been invaded by its neighbor. That is a solid Article 51 argument. So that it's not law that's preventing us from coming into the war directly on behalf of the Ukrainians. It's fear of nuclear Armageddon is what's stopping us. And so nuclear weapons are in the background all the time of this conflict. And we're learning a lot as it begins to unfold. And I hope the lesson continues to be that states are going to see nuclear weapons as a kind of off-the-table option. But the more that lesson becomes clear, the likelihood of conventional warfare again may grow. And that itself is a troubling development.
Hi.
Hi.
I have so many questions, and all I've been doing this whole session is trying to distill them down into one, but it's very hard. I'm a 1L student. My name's Cassie. I went to school in the U.S. Actually, I was at George Washington for my undergrad, so I have a lot of international affairs kind of experience. My question, I'm going to do something different. I'm going to pose two questions, and you can choose to answer one.
Okay.
You can answer both if you're able to with the time that we have. I was actually, when I was a student at GW, I was given the pleasure of actually working for the Human Rights Council, the UN Human Rights Council in Geneva.
Great.
Got to see the practical experience of the international justice system at its finest and saw all of the flaws. Yeah. So that was very hard, to the point that the gentleman made. I kind of wanted to answer a part of his question and kind of refute it a little bit. But in my question to you about, the need for the international justice system, because you mentioned that the West, this kind of world order, this new world order could be very much backed by the West, but ultimately the global South needs to be heard. And I'm wondering if it's the responsibility of international institutions like the UN for that to happen, or if it is the West. And I'll give you an example of that I've thought about recently with UNGA, because I heard in a podcast recently that in September, this past September, UNGA had only the US as one of its permanent members there. France and the UK were not there. China, of course, and Russia were not there. Yeah. And so, there was a lot of talk about, well, is UNGA losing legitimacy? And that makes me think, and they're talking about how the G20, G7, a lot of these Western countries are having these sorts of bigger conversations in more of a closed-door setting. And I'm wondering if that's actually contributing to the abstentions and the kind of, global South and other countries from feeling like they're not having a voice in all of this. So that's my first little point.
Lay down the law and say it's one final question. I think that's enough for you to chew on. It was a great question.
No,
Thank
there's
you.
so much. There's so much there. That's fantastic, and happy to follow up. I think that this is. I think that you raise a lot of really important questions. So the UN General Assembly has, it's 193 states. It's a lot of states. It's hard to meet in a full session of the General Assembly. And what I have seen, and again, I'm still a novice a bit at the UN politics and what I've seen unfold, but what I've seen has actually been really interesting, because ideas form in sort of smaller groups. So this idea of special tribunal for the crime of aggression, or the veto initiative, start with idea entrepreneurs, really people with ideas. Again, people with ideas really play a significant role. In fact, the little mission of Liechtenstein, you would think that they would not have much sway, but they have lots of willingness to push forward ideas. They're particularly attached to the crime of aggression and the importance of the crime. The little country can't defend themselves if all of a sudden the rules against the use of force suddenly disappear, and so have a real vested interest in pushing forward all these initiatives to try and support the strength of the United Nations General Assembly and overcome the veto and to push forward efforts at accountability for the crime of aggression. And conversations start in smaller groups and then move outward. And there's an effort to kind of build constituencies for these ideas and a recognition that in order for something to succeed, you've got to make your case to a lot of nations, and a lot of nations, not just those that are in your region, but outside of your region. And part of what I find so powerful about the General Assembly is that the more these things are happening in the General Assembly, the more it is necessary to make your case to the Global South. Because it's very hard to be successful on these resolutions without getting the Global South on board. Whereas that's not necessarily true in the Security Council. And so, while it's true, yes, sometimes people don't show up to meetings and whatever. That's absolutely true. But actually, I think what we've seen is this growth of the legitimacy of the UNGA, and it's still kind of nascent. Some of these initiatives are relatively recent and new, and there are real questions about the role that UNGA can play. And one of the debates was around, is it lawful for the UNGA to create a special tribunal? And part of what I've been trying to make the case for is yes, it is, and here's why. But I think there is this growing legitimacy. And what's really interesting, and to the US's credit, it has been supportive of this move so far. It supported the veto initiative. It supported the role that the UNGA has been playing in sort of taking a greater step forward and playing a role in global governance. And my sense is that this is a positive development for the UN, because I think the UN, if it's seen as just a Security Council, it's seen as representing just a small number of states. And it's so kind of stuck in time. It's so much a creature of the post-World War II era. Whereas the UNGA as a whole is, every state has a voice, every state has the capacity to bring an idea forward, and their ideas really do matter. Having people passionate about, even individual representatives, passionate about a project and being willing to push forward and try to make the case for it can actually make a real difference. So I've been really excited about that. I'm part of a new initiative, a rule of law initiative that the Mission of Austria is now bringing forward to try and increase rule of law in the Security Council. And we're doing a series of talks and conferences. The first one's next month. And trying to think about how do you strengthen the role of the UN and rule of law. And these are all the kinds of questions we're starting to ask. I don't have all the answers, but this is the sort of thing that hopefully your generation is going to help us figure out. So thanks for the question.
First of all, let me say we have been so incredibly lucky to have you here, not just because of what I'm about to say, but also because it sounds like you are everywhere. And so it's really, really lucky that it's worked out for you to do a stopover in Toronto. I want to thank you for a really inspiring lecture. For me as an international lawyer, it's nice to hear a fellow international lawyer speak with hope about international law and also speak with conviction and in a convincing way about why it is so important, and building on the points that you made at the end, and you made them at various points, the importance of ideas and people actually doing law, because it is something that we do, and unless we make it happen and we insist on it operating, it doesn't. So you are certainly someone who's doing a lot of very important work. I also want to actually have to say, I don't know, colleagues here will probably agree that it's rare that we go right to 6 o'clock with question and answer, back and forth and back and forth. So that really is also a tribute to how wonderful this has been, and you've been very generous in answering all manner of questions. Thank you very much.
Thank you. Thank you so much. Thank you, everybody.